Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. This video deals with the reference. So what is the reference? While discussing section 114, 115 of the Civil Procedure Code, I told you what is the reference. Reference means whenever the court conducting trial gets a doubt about the validity of certain act, about if there is any ambiguity regarding the provisions of the act, when there is a conflict between the Central Act and State Act, definitely they can refer the matter to the High Court or the Honorable Supreme Court of India for getting clarity. So this is the very purpose of reference. So such topic of reference has come from the lower courts, even from the High Court also, regarding section 319 CRPC. What is section 319 CRPC? 319 CRPC means summoning of the additional accused. So whether it can be done during the trial or whether it can be done even after the judgment or whether it cannot be done after judgment, like that. So the question has come. The reference was made to the Honorable Supreme Court of India and they have given clarity with certain guidelines. So please, this relates to the case of Sukhpal Singh Khaira. Sukhpal Singh Khaira versus State of Punjab in Criminal Appeal number 885 by 2019. So in this case, Honorable 5 Judges Bench, Abdul Nazir, B.R. Gawai, A.S. Bopanna, B. Ram Subramaniam and Madam B.V. Nagaratna. So they have answered to the reference regarding section 319 and clearly answered that trial court has got power of summoning additional accused only before judgment or before conclusion of trial. After conclusion of trial, please remember, only reopening the case or once again trying the case. That is the answer and that answer given per the reference. Now, we will go to the facts of the case. Actually, this is a case relating to NDPS Act. Our appellant, that is Sukhpal Singh Khaira. Actually, an FIR was registered against him and 10 others, total 11 members, in some police station. Okay. PS Sadar of Jalalabad in Punjab. The case was registered on 5/3/2015 against the appellant and 10 others under sections 21, 24, 27, 28, 29 and 30 of NDPS Act, that is Narcotic Drugs and Psychotropic Substances Act, as well as 27 of the Arms Act and also section 66 of the Information Technology Act. So almost all important sections of law were imposed against him and 10 others. Right? So that means in a stage of drug addiction, they have definitely they try to molest a woman and they have made the videos and things. It might have, that may be the case. Actually, I do not know the case. Okay, the police filed the charge sheet on 6/9/2015, not against the appellant, against the other 10 accused, and it is pending trial. Right. So actually somebody raised some objection. The police filed an additional charge sheet. Even the additional charge sheet also no mention of the name of our presenter Sukhpal Singh Khaira. But during the time of trial, almost the trial is about to be completed. At the time, basing on the witnesses PWs 13 and 14, they have been re-examined under section 311 CRPC. You may be knowing. So whenever the examination is not completed, so the prosecutor can ask for reopening. So their evidence has been reopened. Their evidence is recorded where they stated the name of our appellant. But by that time, now since they have mentioned the name of this person, the prosecution filed a memo for adding or for summoning the additional accused Prem Singh Khaira under section 319 CRPC. So whether before it is allowed or not, discussions are going on. The trial in the main case is completed. It is about to be given the judgment. So at that time, the trial court negated. That means, so we don't want to summon him as additional accused. So then came the High Court. High Court also stated that actually they can be added provided since the time of judgment they cannot be added. Ultimately the matter has come to the Supreme Court. Now the point is whether they can be added or not. Supreme Court clearly stated that yes. The High Court and Trial Court are also correct, stating that the summoning of the accused should be done before the trial is completed. In this correction, they have given certain guidelines also. Please remember. Oh, I'm sorry. In this case, 319 application was allowed on 31/10/2017 and he filed objection. So therefore, the revision, right? Anyway, the lower court and the trial court allowed. So therefore, they have the Singh Khaira has come to the Supreme Court, right? Now the guidelines will read. Section 319. Section 319 CRPC petition can be allowed if there is additional evidence. But please remember, it can be allowed before the conviction or acquittal. So if the judgment is about to be given, no. And before the judgment or before the conclusion of the trial, yes, definitely summoning of additional accused can be done. But please remember, the court has to decide first whether there is any need to give summons to the accused. So there should be enough cogent and sturdy material to say that the accused has also participated. Otherwise, simple allegations, they need not be involved. Then please remember, such orders, that is summoning of the additional accused under section 390 CRPC, should be given before proceeding with further trial. Please remember, if there is further trial, then only this has to be accepted. Otherwise, no. If it is a separate trial, no problem. So if you want to conduct the trial separately, you can add him even after the trial also. Right? Please remember, when the case is convicted or acquitted, there is no impediment or there is no need. So need to add 319. So after conviction or trial, no question of 319, only separate trial. Please remember. Rehearing, of course, you can have the rehearing, maybe another option. So please remember. So if at all you wanted to take it on file, the main case may be decided and the second case may be continued. That means de novo inquiry or de novo trial. Once again the trial is. So these are the guidelines given by the Honorable Supreme Court of India. So in this case, what you have to learn is, please remember, section 319 CRPC అంటే summoning of additional accused. అంటే ఏమిటి, ఒక కేసులో 10 మంది మీద ముద్దాయిలు పెడితే మధ్యలో కొంతమంది పేర్లు వస్తే వాళ్ళను కూడా కలపవచ్చును. ఎప్పుడు ఇది? జడ్జిమెంట్ ఇచ్చిన తర్వాత కాదు, జడ్జిమెంట్ కేసు రెడీ అయిన తర్వాత కాదు, ఫర్దర్ ట్రయల్ ఉంటేనే. సో మరి జడ్జిమెంట్కి వచ్చిన తర్వాత ఆ లాస్ట్ మినిట్లో చెప్తే యూ కెన్ కండక్ట్, మీరు కొత్త ట్రయల్ వాడి మీద, మిగతా వాళ్ళ మీద జడ్జిమెంట్ చెప్పేసి అతని మీద మాత్రం ట్రయల్ కండక్ట్ చేయవచ్చును. అండ్ లెబోరియస్ ప్రాసెస్ కంటిన్యూ చేయాలంటే మళ్ళీ ఈ సాక్షులందరినీ విచారించాలి. కాబట్టి ఏదైనా బిఫోర్ ట్రయల్ అయితే ఎస్, ది కోర్ట్ కెన్ యాడ్ ది కెన్ గో ఫర్ ద సమ్మనింగ్ ఆఫ్ ది అడిషనల్ అక్యూజ్డ్. సో ఇది ఎలా వస్తుందంటే, మాకు యాక్చువల్గా క్లియర్గా నాకు ఒక కేసు జరిగింది. ఒక వ్యక్తి ఒక మాల్ కన్స్ట్రక్షన్ అప్పుడు దాంట్లో వర్క్ చేస్తూ ఉండేవాడు. అతనికి ఫ్యామిలీకి డిస్ప్యూట్ ఉండి మొత్తానికి హీ హాజ్ కమిటెడ్ సూసైడ్ జస్ట్ బై ది సైడ్ ఆఫ్ ద మాల్. వచ్చిన తర్వాత ఆ మాల్ యొక్క ఓనర్ గారు లేడు. హీ వాజ్ యాక్చువల్లీ ఇన్ నెల్లూరు అట్ ద బై ద పర్టికులర్ టైమ్. ఆన్ ద నెక్స్ట్ డే హిజ్ మేనేజర్ హ్యాస్ గివెన్ ద రిపోర్ట్. సో ఆయన ఓనర్ గారు వచ్చి, నాకు నెక్స్ట్ డే తెలిసిందంటే ఐ వాజ్ అవే అట్ నెల్లూరు, నెక్స్ట్ డే ఓన్లీ ఐ కేమ్ టు నో. బై ద టైం మా మేనేజర్ వాళ్ళంతా ఏదో ఫోన్లో చెప్పారు కానీ నాకు పెద్దగా తెలియలేదు, వేరే పని మీద ఉన్నానంటే. సో పీపీ గారు కోపం వచ్చేసి, నో ఈజ్ ఆల్సో ఇన్వాల్వ్డ్, నెల్లూరులో వెళ్ళానని చెప్పి చెప్తున్నాడు, కాబట్టి ఈ మే బి కాల్డ్ యాజ్ అడిషనల్ అక్యూజ్డ్ అని చెప్పి మేము పడేసేసింది. అండ్ ద కోర్ట్ సైడ్, వాట్ ద పర్పస్? ఈజ్ దేర్ ఎనీ గ్యారంటీ దట్ ది ఓనర్ హ్యాస్ టు నో అబౌట్ ది థింగ్స్? ఓనర్ మే బి అట్ సమ్ అదర్ ప్లేస్, he came to know, he is giving evidence, next day వచ్చారని చెప్తున్నాడు అని చెప్పి నాట్ అలౌడ్ దట్ 319 CRPC పిటిషన్. కాబట్టి ఇలా రకరకాలు జరుగుతూ ఉంటాయి. బట్ ఎనీవే 319 వెయ్యాలి అంటే, ఒక ముద్దాయిని ఎక్స్ట్రా ముద్దాయిగా చూపించాలంటే ద కోర్ట్ షుడ్ బి వెరీ వెరీ కాషస్. దిస్ ఈజ్ వాట్ ఐ వాంట్ టు టెల్ యూ. సో ఐఎమ్ కంక్లూడింగ్. and I will come up with some other matter in my next video. With this, I am concluding. Thank you very much.